Welcome, everyone. I'm Matt Erpelding. I'm the Vice President of Government and Community Relations from the Boise Metro Chamber of Commerce. And today we have a conversation with Attorney General Lawrence Wasden. The Attorney General is Idaho's longest serving Attorney General, and he has a deep understanding of the history and politics in Idaho. And I'm very excited to get to our conversation with him in just a few minutes. But before we get started, the Boise Metro Chamber of Commerce is Idaho's only 5-star accredited member of the U.S. Chamber of Commerce. And our ability to attain that accreditation is driven by the investments that our members make in this organization to be able to provide services to the community. Today's event is sponsored by Angstrom & Johnson attorneys and counselors. They're a longtime member and they have been involved in our community for a very long time. And we are very grateful that we have their support for this conversation with the AG. But one other thing before we get started, the legislature is in session, and we will also talk a little bit about civility in our politics. Civility increasingly is a concern for the Boise Metro Chamber as we look at the interactions everywhere from the federal level in Washington, D.C., all the way down to our local level. We feel these conversations are a key piece in demonstrating how important civility is and how important it is to have conversations that aren't always comfortable, but in a way that allow for different values to be heard. So with that, I'd like to introduce Attorney General Lawrence Wasden. The AG was first elected in 2002, and he is the 32nd Attorney General serving his 5th term. He's the longest serving Attorney General in the state's history, and he started working in the office in 1989 when he was appointed as a Deputy Attorney General and assigned to the Tax Commission. He was then promoted to Deputy Chief of Staff, then later Chief of Staff. Prior to that, he served as a Deputy Prosecutor in Canyon County, and he earned his JD from the University of Idaho and was admitted to the Idaho State Bar in 1985. He's an alma mater of Brigham Young University that he graduated from in 1982 in political science. He's a founding member and past chairman of the Government and Public Lawyers section of the Idaho State Bar. He serves on the University of Idaho College of Law Advisory Board. And he and his wife, Tracy, have been married since 1980, live in Nampa, where they're proud parents of 4 children. And as a person with a young child, 13 grandchildren, which I just think is so impressive because I've got a 3-year-old and I can't even imagine getting to where I get to celebrate her kids down the road. So welcome, Attorney General Wasden. It's really an honor to have you here and to have this conversation. Before we get started, just really quick, how are you personally handling the pandemic, and how is it impacting your office?
Yeah, it's the pandemic has been challenging for my office. I have a number of people who are medically challenged, and so we've had to be very careful. It has required us to reduce the interaction in our office. Most of my work is, most of my office members are at home, working from home. We find that maintains, but our greatest production comes when we're able to sit with each other and talk with each other. There's certain element of looking face to face with people where you are able to accomplish more. But we've been able to maintain to produce the work we need to, but it's also much more difficult because we've had to, as an office, not have that time together, and people are at home trying to protect people's health. Personally, I am in the office occasionally, but as you can see, I'm home right now. So I do a lot of that from home, again, to reduce the interaction and to protect people's health and lives. So it's a challenge, but we've met the challenge and we're going to overcome it. Matt, I can't hear you for some reason.
You know, I've done like 70 of these, and that's the first time I've ever not unmuted myself. So epic rookie move for a non-rookie. I wanted to ask you, I've been working on a project with several other former legislators, Kelly Packer, Luke Malik, and also former County Commissioner Diana Lacciando, called In Search of Civility. And over the years, you and I have had both collaborative opportunities and some real conflict. And I wanted to get your take on civility, particularly as it relates to our next topic for that series, which is partisanship and power, and the application of power as a way to basically be uncivil. And I wanted to get your take over the last, you're 5 terms in, and the legislature has certainly shifted, and that's not just the legislature. In general, our country has become more polarized. It's very worrisome. And what is your take on civility right now, and how does that specifically apply to the application of power from the AG's office?
Well, I think that the relationship that you and I have had over the years has been actually a sort of a model. And I'm not saying it was perfect, because you and I had some pretty tough conversations. But what we never did is we never stopped talking to each other. And it didn't resort to name calling. It was differences of point of view, fiercely held. I mean, significantly held differences of point of view. But you and I continued to talk to each other no matter what the issue was. And that's what I think is so important. When we boil down to simply demonizing and name calling the other side of an issue, then we don't really listen. And listening is, at least 50% of communication, and perhaps even more. So I think that as a society, we have kind of fallen into a trap. I'm not blaming the internet, but I think the anonymity allowable in the internet enhances or exacerbates that problem. Recently, I've been called a whole lot of vulgar, ugly, nasty names. That doesn't actually enhance the interplay, the dialogue between parties. What would actually help is if people listened to each other, and actually, even if you choose to disagree, to understand somebody else's perspective. And I actually wanted to take a moment and thank you for your service to this state. You served in the legislature for a long time. We worked well together on lots of things. And yes, we had disagreements, but we even worked well when we had disagreements. And I thank you for that.
Well, I appreciate that compliment. Same to you. And I mean, even when we were outside the Capitol, kind of almost yelling at each other, we knew that we had to come back together to have a larger conversation. And I'll never forget those interactions. You're the longest serving attorney general in the state of Idaho, and that's a major accomplishment. You're on your 5th term. And the first question I have is, what do you consider your greatest accomplishments or your greatest accomplishment? And what do you kind of look back and think, maybe I should have done that, handled that differently?
I'll take the latter half of that question first. What could I have done differently? And when I was first in office, I made a decision actually without taking, contrary to what I normally do. I didn't take time to think about a decision. I wasn't as objective, and I wasn't as studied on the matter. Made a decision that actually ended up not working out very well. And so that was a very significant failure on my part, and I have to take responsibility for that. It had to do with some legislation and resolution of some school funding issues, and I never repeated that. I wish I had not. I wish I had not made that error in judgment in that instance. Some of my best accomplishments, the thing that I guess I take the most pride in, is not a very flashy issue. It's the fact that what I have created in terms of the office is an environment where lawyers can do the job they're hired to do. I care about the rule of law. I don't care about people's personal politics. What I do care about is that we practice law in a way that is objective and straightforward. So when I'm asked a question and required by the law to give an answer to a member of the legislature, that we're not feeding them the political viewpoints. What we're doing is analyzing the Constitution and the statutes and giving them a specific answer. And the reason for that is that that's the best way to serve the legislature, allowing them to make proper decisions. They make the policy decisions, allowing them to make those decisions in a way that serves the public. So what I'm most proud of is that we have been able to create an environment where we're actually fulfilling the responsibility that we have. And there were people who said I couldn't do it. And I'm not patting myself on the back, but the fact is I've got a lot of really, really good people who have the wherewithal, the tools, and the stamina and the professionalism to make hard decisions and to call those balls and strikes fairly and squarely. And I think that's a very significant contribution to our state.
We have people that are watching that are from every stripe of life, whether it be the folks that are watching on our Facebook page, our LinkedIn page, all of these places. So we have experts about your office, and then we have novices about your office. Before we get into some of the harder questions or more nitty-gritty questions, I guess, can you just give us a breadth of the size of your office and the different divisions and how they serve Idaho?
Yeah, first of all, I guess we ought to probably start off and say, what is it that the Attorney General does? And because a lot of people are confused, sometimes people in the legislature are confused. I'm not a cheerleader. I don't say, hey, this is a great policy, this is a great proposal, pass it. That's not what I do. What I do instead is I'm asked the question, what are the legal implications of this proposal? And so in that environment, what I do is I analyze the Constitution, I analyze the statutes, and I say, this is what you're proposing means, and this is how it is impacted by the Constitution and the statutes. I'm not saying it's good, I'm not saying it's bad. In fact, one person said to me, well, you always say my proposals are unconstitutional, you just don't like me. And it's not it. It's not a personal matter. It's not, do I like you or do I not? Do I think this is a good idea? Do I think it's not a good idea? My opinions aren't based upon whether it's good or bad. And saying something unconstitutional, it may be the greatest idea known to mankind, but if it violates the Constitution, it violates the Constitution. And I don't get to change the rules based upon whether I think it's a good idea or not. So a lot of folks misunderstand. I don't make the policy choices. What I do is enunciate the law to the best of my ability. And when you think of that, I'm required sometimes to look into a crystal ball and to try and predict how a court's going to react to something. So there's a level of uncertainty, a level of unknown in what I have to do. But when I make those choices, it's not based upon what I think the law should be, and it's not whether I like it or dislike it, or whether you like it or dislike it. It is based upon this professional judgment acquired over many years. What do I think the court's going to do, and how will it deal with this issue in light of the Constitution and other statutes? In terms of the breadth of my office, we have about 210 employees, 205, somewhere in that neighborhood. It changes occasionally. And about 120 and 125 lawyers. People say, well, do you really need that many? And the answer is yes, we actually do. When you consider the fact that the state budget's about $6 billion. So that's about the size of a $6 billion corporation. And we need that many lawyers that have expertise in a whole variety of areas. So you talked about the divisions. We have a division called the Administration and Budget Division, and they manage our computers and our pencils and paper and all of those kinds of resources that you have to run an office. Have a criminal law division. We handle somewhere in the neighborhood of 150 to 100 special prosecutions. Those are very high profile, intensive cases. Handle about 1,000 criminal appeals every year. So when a case is tried at the district court level, we handle the appeal. So we have a very significant workload in that regard. We also represent the Department of Law Enforcement, Department of Corrections, and so forth out of that division. We have a Natural Resources Division, which I call Fish, Air, Dirt, and Water. We litigate all those cases that the state is involved in, managing wildlife, managing water, agriculture, a whole variety of things in that regard, all the dams, fish, all of that stuff. And so we have our fingers in a lot of pies. Again, we're not the policymakers. We're the ones who are saying we are litigating on behalf of the state every time we get sued or bring an action. That's what we do, is we're doing the legal aspects of that. It's not the policy determinations. We have a division that is a civil litigation division, and we litigate cases. The state's sued every week. I get a stack of complaints that are filed against this state every week. Somewhere between, between 3 to 7 or 8, 10 cases a week. It just depends on the week. And we have to respond to all of that. And once one of those lawsuits is filed, it requires a year, 2 years, and maybe more to resolve that. In fact, we just resolved the case that had been in existence for 39 years that we've been litigating, and we resolved that a couple months ago. So we litigate those issues. We have contracts and administrative budget division. So the government operates by contract. So we're advising on contracts, has a whole bunch of small agencies and boards that we provide legal advice to by law. There's a Department of Health and Welfare, Human Services Division. So we provide advice and litigate on behalf of the Department of Health and Welfare. And that's a very significant part of what we do. So we have a wide variety of things that we have to deal with as well. We have a Consumer Protection Division, which I'm sure you're aware of. And so we have quite a wide variety of things that we deal with, a great breadth of things. We cover legal advice in all aspects of state government. We don't make the decisions for elected and appointed officials. We give them legal advice before they make a decision, if they ask for it. And then we defend them. We protect their decisions once they've made the decisions. I don't make those decisions. Does that explain it a little bit? Matt, again, I can't hear you.
Oh my God. It's a good segue into this challenge that you have, in that you represent the legislature. So you're the attorney of record, or however you define it, as with the legislature. And the result of that is that there are times when you give the legislature advice that they disagree with. And the thing that makes that kind of a sticky widget, and I wanted to ask you about it, is the legislature holds your purse strings. So they're the ones that appropriate money to your office. And there's constantly attempts, particularly on the House side, to kind of tinker with budgets with folks that they don't agree with. And I was just wondering how you navigate that, and why that is. Because for me, you gave me a lot of AG opinions that I didn't care for. But I didn't think, oh, well, I should go and potentially defund the budget over here. And as we've been talking about civility, it seems like we're kind of knocking on that. So just wondering what your thoughts are.
Yeah, well, a couple of things. By law, by statute, it's actually 67-1401 and 67-1406, I believe, but that chapter 14 of Title 67. It says that I represent the legislature, the governor, and the judiciary upon their request. So what that means is that I'm a captive lawyer, but they are not a captive client. So they, if they ask me to represent them, I'm required by the law to represent them. I'm not offended by that at all. And if they want to use counsel outside my office, they're welcome to do so, and it's not a problem. Then all major state agencies, I'm required to give them legal advice, and they're required to get that legal advice from me. And then there's a third category of some small boards and commissions, which may receive my legal advice upon my agreement with them. They have to pay for it. It's 18 months in arrears, but they have to pay for it. So in that context, the statute also says that when I'm asked a question by a member of the legislature, I'm required by the law to give them an answer. And my answer is to be based on the law, not based upon what they like. And you point out one of the great challenges that we have. So to deal with that, I've told all of my folks, we don't play politics. We don't sway the answer based upon our personal political view or the people we're answering. It doesn't matter who asks the question in the legislature. They should get the same answer as to what the law is. And so that's how we deal with it. And I respect the appropriation power in the hands of the legislature. In fact, I made my budget speech yesterday, and they call me before them. I tell them what we need, and then we rely on their statesmanship to deal with the issue. And sometimes that works well, and sometimes it works a little less well. So we just approach it in that way.
Well, let's start talking about some of the things that your office has had a really heavy hand in, one of which I care deeply about, and that's the 95 nuclear agreement.
Yes.
The 95 nuclear agreement is kind of former Governor Andrus and Bat's legacy. You are a signatory on the Idaho AG is a signatory on any changes that are made to the nuclear agreement along with the governor. And you've had your hand in the nuclear agreement for a really long time. For context, and you can go into it a little bit more, but I believe Idaho is either the only or one other state has a federal contract that basically is enforceable, that the feds have to remove nuclear waste from the state of Idaho before being able to advance certain types of research or nuclear projects.
Yeah.
The end result is we've been in a quagmire with that since 1995 because we've got an industry in Eastern Idaho that's pretty important to the citizens over there. So can you talk about where we're at, some of the changes that have been made over the last couple of years and its importance to your office?
Yeah, absolutely, Matt. And I guess a little history here to be helpful. And what happened is that when Governor Andrus was in office and the Department of Energy was storing stuff out at INL, or it was also been called INEL and INEEL, and it's now back to INL. And so they promised, the Department of Energy had promised that they were going to remove some very significant stuff from INL and that was just stored there, and they didn't keep that promise. And Governor Andrus had the state police pull a state police car across some railroad tracks to stop a train from coming in and depositing more stuff at INL. And it resulted in a lawsuit being filed against the federal government, Department of Energy, to enforce the promises that Department of Energy had made to us in Idaho, because they were not complying with what they said they were going to do. And in that context, we ultimately were able to negotiate a solution, that is an order of the court about how this would be dealt with. And by the way, you mentioned there's only one of these in the country, and this is it. And other states wish they had what we have. And I know that the Department of Energy in some respects chafes under that, but it's important, and it's important to Idaho. And I will tell you that I fully support INL. It's incredibly important to this state. It's incredibly important to the nation. It's incredibly important to the world, the work that's going on out there. So I support that fully. But at the same time, I have an obligation, and you mentioned I'm a signatory, meaning that I have to sign off on that. I have an obligation to see that the requirements of the 1995 VAT agreement are carried out. And that came to a loggerhead a number of years ago, in which case there were two elements of that agreement that were in jeopardy. One of them was that there's certain stuff called true waste, it's transuranic waste, that is gloves and hats and that kind of stuff, that have been contaminated, and they were put in barrels and sometimes not put in barrels and then taken out in the desert and buried. And that stuff was a problem. And so the agreement required them to dig that stuff up, to identify it, to repackage it, and then to send it to WIP. And what happened was that WIP was being run at a pace and in a way that wasn't entirely safe. They had a truck fire down inside the mine. WIP is it's a mine that it's a salt mine about a mile underground, and they would take the waste and place it inside the mine. The salt would then form around and encrust around those things, holding them stable. It's a completely geologically stable location. It's where the federal government stores this stuff. I'm not saying good, bad, or ugly. I'm just saying that's what it is. But they were behind in terms of shipping that stuff because they had this truck fire, and they'd also had what they call an overpressurization event, which is a container that blew the lid off, and it blew nuclear contamination in some places in the mine. So they stopped shipments. Well, that's a problem for us because we have a large volume of this, and the agreement says they have to move it off site. And the penalty for failing to move that is that our sole remedy is to prohibit them from bringing in additional shipments. The second thing here is that there's something, it's a liquid waste. It's 900,000 gallons of sodium barium high level liquid waste, which sits in 3 stainless steel tanks And the Department of Energy had agreed that they would process that liquid and turn it into a solid by December 31st of 2012. But they didn't do that. And that 900,000 gallons is still sitting there. They had another 900,000 gallons that wasn't sodium bearing, and they've processed that. But they tore down the plant to process it because of some air pollution problems. And we still have this 900,000 gallons sitting there. And it hasn't been processed, not a single ounce. And they created a machine called the Integrated Waste Treatment Unit. And some people fought about whether it's a machine. It's a chemical process inside a vessel that's transported with a auger and a bunch of other stuff that creates this as a solid and then can be stored more safely. And the reason why that's significant is this liquid sits in these tanks above the East Snake Plain aquifer. And it's not a question of if they will leak. The question is, when will they leak? Because everyone, including everyone at DOE, will say, yes, the chemical components here in this liquid material, the nuclear components, will attack the stainless steel, and ultimately they will leak. Unfortunately, we can't tell where the leaks are. We are assured by INL that they're not leaking, but these are not they're not CERCLA compliant. They're not tanks, RCRA or CERCLA. The environmental laws concerning this, because the tanks are sitting on the ground. There's no space. We can't see if they're leaking. There's a sump. There's a whole bunch of other things, but we don't know when they're going to leak, and we don't know. We won't be able to tell immediately. They have alarms and those kinds of things. Now, this isn't just make-believe. Similar situation exists at Tri-Cities in Washington, but they don't have stainless steel. They have carbon steel, and those steel tanks are leaking, and there's a plume of material which is moving to the Columbia River. So it's not like this is make-believe. And given that environment, they came to us and they said, hey, we want to bring in some small amounts of material for the purpose of testing. And I said, I'm most happy to allow you to bring in that material, but first, you're not in compliance with the liquid waste. You have to at least start the machine so that it's processing waste. You don't have to process all of it, but you have to start processing the liquid waste before you can bring these shipments in. In addition, we have to have some kind of agreement about how you're going to get this stuff, the true waste, out of the state and to WIPP. That's where we ended up at loggerheads. I will tell you that at one point, the Department of Energy promised to they said that if we would allow them to bring in this material, they'd take out 300 pounds of additional material, and they would give me a photo op with the Secretary of Energy. I mean, that's actually their words. And I responded to them and said, this isn't about my personal aggrandizement. It's not about my having a photo op with anybody. It's about performance. It's about the fact that we need to protect the East Snake Plain aquifer, which feeds most of the state. It's the water that runs into the Snake River. It's critical to our state. And so we finally were able to resolve this by the Secretary of Energy. And we sat down and we explained it to them. And they said, okay, let's get this done. And we were able to sign an agreement that says, okay, yeah, you can bring in these testing materials, but first you have to start the Integrated Waste Treatment Unit, and we have a schedule and priority shipping to WIPP. So that's all we were looking for in the first place. We want to support INL, but it's critical that we have some definitive requirements regarding the liquid waste and also the shipments to WIPP. So that was a long explanation, but it's a complicated problem.
It is a complicated problem, and it deals with the single largest aquifer in the state of Idaho, and that's really what Andrus and BAT were concerned about. And it goes all the way back to Governor Evans when he forced the INL to stop injecting radioactive water into the ground anyway. So we have a long history, and that's why this one is such a key one, and I think a long explanation is appropriate here.
And Matt, I would add this too. There were a lot of people very upset with me. You know, you're standing in the way of $200 million in economic activity at INL. And the answer is, yeah, I was. But when you consider that $200 million over 20 years, that's $10 million a year, which was the time period. Or even if it was 10 years, it was $20 million. But what would happen if that nuclear liquid material went into the East Snake Plain aquifer? What would happen to Idaho agriculture? What would happen to Idaho manufacturing? What would happen to drinking water? All of those things. And I'm not trying to be a doomsdayer. I'm saying I had the opportunity to do something about that, and I would be remiss if I didn't stand up for my responsibility and protect that.
Well, and it speaks to my next question for you, which is Idaho does have a responsibility to manage our natural resources in perpetuity, in particular our land trust and kind of the state lands requirement. You were instrumental on the land board to end the state's investment in things like cottage sites, right, and move more to an investment model that would, over the long haul, provide investments in education in perpetuity. Speak a little bit to how you came to that conclusion and why it was so important that we move out of commercial real estate or cottage sites and into a more long-term investment.
I guess a little bit of history here is helpful, and that is that when we became a state in 1890, the federal government granted to the state certain parcels of ground. They're called endowment properties. That is, with every township, that is, the surveyor set out townships and squares, and so every quadrant, sections 16 and 36 were given by the federal government to the state of Idaho to hold in trust for the purpose of providing money for education. So this is a trust. And that is that the land board members, who are the governor, the attorney general, superintendent of public instruction, state controller, and the secretary of state, they are trustees, meaning that they manage that property for the benefit of the beneficiaries, not of themselves. They don't do it for political purposes. They don't do it for financial purposes. They have to set all of that aside, and they have to manage it for the purpose of the benefiting the beneficiaries, which primarily are school children. Now, what that means is that, and specifically what the Constitution says, is that the land board is to obtain the maximum long-term financial return. So that means the purpose of those lands is to earn as much money as we can. That's over the long term, that's what we're supposed to do. It isn't to make, political statements and all that other kind of stuff. It's one purpose. It's very different from federal lands. This is not multiple use. It is single purpose. Make as much money as you can. And in fact, in terms of performing this fiduciary responsibility, our Supreme Court has said it is very specific. Your job isn't to go out and look at the community at large. It's not to look at the state at large. It's not to look at industry at large. You have one job. That one job is you make as much money as you can for those school children and the other beneficiaries. And so sometimes people get confused. People have said, well, you really ought to make this into a park. And the answer is there are other things that we can do for parks, but this parcel is to make money. And that's what the Constitution demands that I do. So with regard to the cottage sites, what had happened about 100 years ago, the state was leasing these properties. They happen to be part of these sections 16 and 36. One of them happens to be around Payette Lake. Another one happens to be around Priest Lake up north. And these are very, very valuable properties. And we were leasing those to people who would build cottages, although some of them were very, very expensive summer homes. And so what the leasing process was allowing those people to pay less in a lease payment than they would have been paying in property taxes had they actually owned the dirt. Now, you can't really say under those circumstances that the state is obtaining the maximum long-term financial return. In the real estate marketplace, there's a concept that what really adds value to a property is location, location, location. And so these sites were on the shore of Payette and Priest Lake. That was a major value contributor to these properties. And there's also something contributed by the structure, but the primary contributor was location. So we were not obtaining the maximum long-term financial return. I can get into the numbers with you, but we were getting less than 3%. It was about 1.7%. So you got about a $250 million, about a $250 million asset, and you're getting a 1.7 return, basically because we were not willing, we did not have the political will to obtain what we should have been getting. We had an economist look at it. He said, well, you should be in the 4 to 6% range. And we weren't. We were less than half of that. We were about 1.7. So a number of members of the land board looked at it and said, well, what we want to do is we want to have a different formula for determining what the rent is. But that formula, if you actually read through the numbers, it gave a nominal rate of 4%, but when you did the calculations, it was actually 1.7%. So we really weren't making any changes. That created a great deal of controversy, a great deal of anger. People were very mad. One person got angry and said that I was trying to force them off their leased site. One person sued me because they said I was desecrating the grave of their grandmother, who they had poured her ashes on the leased land. And it wasn't have anything to do with that. It is a singular responsibility, and that is to obtain the maximum long-term financial return. So given this supply-demand issue with regard to these lakeside properties, and no more of them are going to be created, why would I then say we should get out of them? It's because we as the land board had proved over 100 years that we lacked the political will to fulfill our fiduciary responsibility to the school children. So that's why we went through the process. We revalued those, increased the lease rates, and then have sold them, and are now in the process of trying to figure out what do we do with this money and make a proper investment so that we are returning that, removes that whole political element regarding, the people who own these properties. They're people with political power. They're lawyers and doctors and, college professors and a bunch of professionals. They had political power. The school children didn't. My job is to equalize that and to get the proper return. So that's. I hope that makes sense to you, Matt.
Yeah, and I think maximum value in perpetuity.
In perpetuity.
As long as the land is in trust, it's forever, which is kind of the tie-in to the Snake River Aquifer. That aquifer's got to be clean in perpetuity.
Yeah.
Otherwise, it's problematic for the next generation of farmers and so on.
And Matt, on that point, it's really critical, because what that means is, as a land board member, I have a duty to provide money for the school child today. But it also means I have the obligation to provide that money to the school child in the future. And I can't steal the money from the child in the future and give it to the child today. I have to balance that so that I'm accommodating for population increase, I'm accommodating for inflation, and I'm being fair to the child today, and I'm being fair to the child in the future.
In a second here, I want to talk about some of the legal cases that you've been involved in over the years. But before we get to that, this goes back to the civility piece, and I know this is where some of the nastiness has come from, and that is in December, you took the stand that Idaho would not join the case that the Texas AG brought to the Supreme Court to try to overturn the election in 6 states. You had a good reason for that. I want you to talk about that, but also talk about how much that led to incivility and unrest within your own, political party and community.
Yeah, thank you very much, by the way. And so I think it's important to understand what was being asked of the Supreme Court. And Texas filed a lawsuit, a direct lawsuit in the Supreme Court, that the Supreme Court has primary responsibility. It has jurisdiction when one state sues another state, when one sovereign state sues another sovereign state. And so that's what was happening, is Texas, and they didn't talk to any of the other states, simply filed a lawsuit as an original action. That's what it's called, an original action in the United States Supreme Court. And they sued Pennsylvania, or asked to sue Pennsylvania, Georgia, Wisconsin, and Michigan because of the way those states had conducted their elections. So the primary question in this instance is, can one sovereign state sue another sovereign state for that state's exercise of its sovereign authority. That primary question, which is a legal question, has to be answered in the affirmative before the court would turn to this, what we're going to call a substantive question of did those states violate the United States Constitution with regard to the appointment of electors clause. And that's a complicated thing. In fact, I've got a whole PowerPoint presentation. It takes about an hour or more than an hour to actually go through it and understand it, which is not time we have here. So the question then was, for me, do I join and support this, or do I defend the state of Idaho and its sovereignty? That is, in the term sovereignty means not only sovereignty for the federal government, but each of the states are sovereigns, and that means that they are free from outside control, outside control from another state. So that means that if I was to join and I would support Texas suing Pennsylvania, that means I would be supporting California, Illinois, Massachusetts, New York suing Idaho, or Oregon suing Idaho. I don't believe those states have the authority to sue Idaho for the way we exercise our state sovereign authority. So if I don't think they should sue us, then I can't sue them. And so I refused to join that. Now, I will tell you that created all kinds of hate and discontent. I mean, vulgar, nasty, threatening, horrible kinds of stuff. My phones were ringing off the hook. People were mad because my voice messages were full. It crashed my phone system at my office, and how dare I do that? I was not being responsible. I lack courage. I shouldn't be the attorney general. We're going to throw you out of office. I mean, those were the nice things they said. The mean things were really, really awful. And so in that circumstance, you have to keep your head around the fact that what is the question being asked? And the question is, can one state sue another state? And the answer to that is no. And in fact, within a very short time period, about a day or so, all 9 members of the United States Supreme Court answered the question and said no. And they said it with an exclamation mark. They said, no, a sovereign state cannot sue another sovereign state over that state's exercise of its sovereign power. They said it in this way. They said, Texas doesn't have standing, and Texas has not identified a cause of action, a justiciable action that can be taken against another state. And so even the justices who wrote a concurring opinion said, well, we'd let them file it because we think that that's what's required in the Constitution, but we wouldn't grant them any relief. We wouldn't grant Texas any relief. So the Supreme Court answered in exactly the same way I had said, is one sovereign state can't sue another sovereign state. And so you don't get to the secondary answers. And I extend an invitation if people want to understand that in greater detail. I'm happy to come talk about it and explain why I did what I did. Most people were not interested in listening. Most of them were, they had a lot of anger. It was generated a lot online. It was generated on talk radio and a variety of other places. But most of the people who were angry never took the time to actually read the documents that were being submitted to the court. They never really took the time to understand what the true issue was. What you're talking about, civility, I think that's an important element of it, is actually understand what the issue is and then formulate your views regarding what the actual issue is, not what the perceived issue is.
I think also it would have been really easy for you to join the lawsuit knowing that the Supreme Court was going to go, yeah, no. And that would have given you the cover, the political cover, to not have to take a hard stand. You know, you might have gotten shots from the left over it, but it would have given you the cover. So from a bravery perspective, I think taking a stand and saying, actually, this is a larger political question, extrapolate that out a little bit. It could include fights over water, which Idaho is particularly interested in. I mean, there's a lot of issues that this would have had ramifications on.
Absolutely. Absolutely. In fact, Oregon has been threatening for some time to sue Idaho over our COVID-19 response. Whether you like the response or not, the answer is, should Oregon have the opportunity to sue us about how we're deciding to do things in the state? And the answer is no. And so you're right. And it isn't just limited to elections. People wanted to say that, and that's what the court said. But the principle is exercise of sovereign power. That's the real heart of the issue.
Thanks for clarifying that. Your office is often involved in multi-state agreements and settlements with major corporations. I mean, the one that comes to mind for me is the Experian settlement. I believe in 18, it was a $600 million settlement that was distributed to the states. It provided customer relief for the data leak, a host of other things. But coupled with that, Idaho, and you may not be able to talk about any ongoing cases the state has, but Idaho did not join the multi-state agreement with Purdue Pharma and opioids.
Right.
So talk a little bit about some of the big cases that you've taken part in, settled, the amount of money that's come back to customers for relief, but also money into the state coffers. And if you could, at the end of that, talk a little bit about why you didn't join Purdue Pharma's multi-state agreement and what your rationale was for that.
Can we start off with Purdue Pharma right now and just
Sure.
answer that? And the answer is, I didn't join. I did join the multi-state action. What I didn't join was a resolution that I thought was too small. And so I can't talk about where we are in that right now because it's at a time period where we're still negotiating. So to correct that, or just make sure people understand, we are actually actively litigating the opioid issue with Purdue Pharma. It's just that some attorneys general thought, well, we're going to take this settlement. And I said, that settlement isn't sufficient. It doesn't really address the problem, and it creates other problems. And I'm not going to join that. What I'm going to do is push for a different resolution of the case. So does that help you understand what it is we're doing there? So what the reason this comes up, and I want to draw a distinction between what people say are class actions. Class actions are brought by private plaintiffs and their lawyers. States really don't engage primarily in class actions. What we engage in is statutory enforcement actions of consumer protection laws. So a major case, what is it, the tobacco case, which has produced about $500 million to the state of Idaho since 1998. And you mentioned one, Experian. We just finished a couple of others. One of them was a $575 million settlement with Wells Fargo. And what Wells Fargo was doing, you may remember this, and actually the CEO had to leave. What they were doing was they were falsifying records and opening bank accounts that some of their customers didn't know about. They were compensating their employees based upon the number of accounts that were open. So that was, employees were basically lying and opening up a bunch of accounts. People didn't know about them. And a variety of other things like that. And so, because if they're doing that in Idaho, they're probably doing that in Montana, and they're doing that in Texas, and they're doing that in Missouri and a bunch of other states. So together we talk to each other and we find out, oh, that's what they're doing. So we then form a multi-state investigation, determine what the facts are, and pursue the case. That one ended up in a $575 million settlement. We've had others that are of a similar nature. We just finished one with Apple. It's a $113 million settlement because Apple was, they had some problems with their iPhone, and they were slowing down their iPhones, and they were attempting to, they weren't covering it up. They weren't telling people what the problem was. Some people ended up having to buy new phones, et cetera, et cetera. They were slowing down the information flow to those phones. And so you have to be honest in the marketplace, and that was deceiving the consumer. And so we engaged with Apple and settled that for $113 million. There was a portion of that money, about $1.28 million, came to the state of Idaho. So it's really not that we're out targeting industry. It's that when we receive complaints, it's likely that our sister states are receiving similar complaints, and we combine together, and we're able to resolve issues in a much more efficient and better manner because we work that way.
That was the tobacco settlement. That was a 50-state settlement.
Yeah.
That was enormous one. And the end result is the state amended its constitution to permanently entrust the Millennium Fund dollars, which is used for all kinds of things, from smoking cessation to, drug education, all kinds of things. And so there are examples of cases where Idaho was involved in something that had a state-altering impact over the long term, and so we're thankful for that.
Matt, did I answer that question in regard to Purdue Pharma? If you understand?
You did. I understand there's ongoing litigation that the state is involved in, which is why you were not a participant in the multi-state settlement. Yeah,
correct.
If I framed that incorrectly, that is my own.
We're good.
I got one more question. It's a nuts and bolts question, and then we'll call it a day. But the AG's office is an office that has tentacles everywhere, and I don't think a lot of people understand how important that is. But at some point before you were AG, they determined that deputy AGs should be within executive branch offices, so Department of Labor, Commerce, all kinds of places, and they work on behalf of that agency, but they report into the AG's office. Over the years, there have been a lot of suggestions that that should be decentralized and that the agencies should be able to hire who they want, how they want. Talk a little bit about why that system is in place and why it's important, and why the other idea might actually not be as simple as some think it is.
Well, this has actually got a lot of history to it, and that is 100 years ago, all of the attorneys in the Attorney General's office were consolidated under one office. And the Attorney General was of one political party. I think he was a Democrat, but I don't remember. And the legislative body was of another political party, the other one, whatever it was. And they got in a fight. And the legislature then broke up the office of the Attorney General. So for a long time, you had people that were in the central office of the Attorney General and responsible to the Attorney General. And then you had lawyers in agencies that were hired essentially by the agency and yet still were part of the office of the Attorney General. And then you also had lawyers in agencies that were not hired by the Attorney General. And so you had this mix of situations, and it ended up actually in an instance when you had two agencies suing each other and the state representing both of those agencies. It's a reported case before the Idaho Supreme Court. So you, the taxpayer, were paying for the lawyers to litigate state agencies in front of the United States, of the Idaho Supreme Court. You're paying everybody's attorney's fees. That doesn't make a lot of sense. So in about 1990, early 1990s, 92, 93, the legislature took all of the attorneys from all throughout state government and reassembled them under the office of the Attorney General. Now, why is that significant? Well, a couple of things is it, first of all, reduced the cost of legal services to the state by a significant amount. And we used to track that. We don't track it anymore, but it cut it almost in half. It was a lot of money that we were saving. The second thing is that when you're advising an agency and you're essentially owned by that agency, it can have some effect on the advice that you give. Our job is to give good, solid legal advice, and actually it enhances agencies. And by the way, it protects the public when that lawyer can give them advice that they don't want to hear, that they can't be fired because of the advice that they're giving. That actually enhances the ability of the lawyer to give the advice that the agency needs, even if it doesn't want to hear it. That makes some people upset. And there's talk, occasionally of, well, we ought to allow the agencies to hire whoever they want to. Well, what I do is I actually talk to the agencies as we are hiring people, so they're comfortable with who they have in front of them. But that person answers to me, and that gives that political break so that they can give legal advice and not be worried about losing their job. And the governor has the power to reassign any of the deputies in my office at any time. So the governor has the power to do that. But it allows us to give good, solid, proper legal advice to those agencies, even if they don't want it. And that's what protects you as the citizen, is that we're not manipulating the legal advice.
I think that's a really important point, is that the agency or the agency director cannot fire the DAG for giving them advice that wasn't A, politically expedient, or B, what they really wanted to hear in order to accomplish said proposal. And so it allows for some independence in government, which is kind of how the executive branches are broken out.
Right.
One last question for you. This question came in from the comments section, and that is this. On more than one occasion, including when I was in the legislature, your office wrote an opinion that indicated that a law was unconstitutional or would be unconstitutional if it was passed and signed by the governor. But as soon as that same law that your advice said, hey, this thing is probably not constitutional, becomes law, you are then required to defend said law, even though you may have said we don't think that this is constitutional. How do you walk that line, and how do you then get your dads to stand in front of a court and defend something that fundamentally they are not on the same page with?
Well, that's a really good question. And first of all, I think it's important to understand that under the Idaho Rules of Professional Conduct, that sets up the rules regarding conflicts, that the rules themselves recognize that the conflict application to the Attorney General is different from the application to lawyers in private practice. And the comments to that section actually identify it and say that the Attorney General just has a special role, and so this may happen. So the way the statute operates is this: if I'm asked a question concerning a matter before the legislature, I'm required to give them an answer, and my answer is to be based upon the law. So I examine that, and again, as I explained, I have to maybe look into a crystal ball. I have to say, here's the law. This is what we think is going to happen. This is how these cases, the prior cases applied. This is how they affect and apply to this case. And the legislature doesn't have to take my advice. They're not required to. And they can make their own policy choices as they choose. They often do. When that happens, it is now the law, and I have taken an oath to uphold the Constitution of the United States, the Constitution of the state of Idaho, and the laws of the state of Idaho. So now, once that is passed by the legislature and signed into law, it is now a law, and I have the obligation to defend that. And we oftentimes will end up with our own analyses being cast back at us. And the answer is we make the legitimate legal arguments we can on behalf of the legislature. It's not actually on behalf of the legislature, it's on behalf of the state that sustain the constitutionality of those pieces of legislation. It takes lawyers with a great deal of talent and a great deal of professionalism to do that. But it is the obligation that I have, and it is a unique and special obligation of the Attorney General.
I just think it's a very special obligation of the Attorney General. Attorney General Wasden, Lawrence, it has been great talking with you. We could go on because there's just so many topics that I'd love to talk to you about that your office has its responsibility to. But I just want to thank you for taking time. I also want to thank Angstman and Johnson, attorneys and counselors. We are so lucky to have you as a member of the Chamber of Commerce, Boise Metro Chamber of Commerce, and we appreciate your investment in our organization so we can have interviews and conversations like this. And one other thing, Lawrence, I'm really glad you turned down that photo op with the Department of Energy. But thanks for doing this, and I'm happy to offer you a photo op down here at the Chamber. So if you want to take it, you can walk over anytime.
I'll take you up on that. In fact, the Department of Energy was very, very angry at me for even saying that, but those are the exact words that they used. In a responsive letter to them, I said a publicity opportunity. I didn't say photo op, and they just went ballistic. They were so angry at me. But I have to tell you, Matt, again, thank you for your service to this state. I greatly appreciate your professionalism. I appreciate this opportunity. And I'm grateful to the members of the Chamber of Commerce. And not everything that I do, they're going to agree with or like, but I extend this invitation. And that is, if you don't understand why it is, or even if you just disagree with me, let's talk. Let's have that civility that you're talking about. Let's understand each other. And if we disagree, let's agree to disagree, not to be disagreeable. So thank you very much, Matt. I really appreciate this opportunity.
Thank you. And to those that are watching today on all of our different channels, we have two events coming up that you might be interested in. One is on February 10th with two freshman senators, and it's a unique partnership between the Coeur d'Alene Chamber of Commerce and the Boise Metro Chamber of Commerce. We'll be having a conversation with first-year legislators, Senator Ali Rabi from District 17 and Senator Peter Riggs from District 3. Both are first-year senators, as I mentioned, but both are also two of the youngest members of the legislature and have a very different view than the overall makeup. The second one is the second installment of In Search of Civility with former Representatives Kelly Packer, Luke Malik, myself, and former Ada County Commissioner Diana Lacciando. That's on February 16th at 3 p.m. And like I said at the beginning, the conversation really revolves around partisanship and power. Kind of the idea that just because you have the power doesn't mean you should enforce the power. I want to thank you again, Lawrence. It's been great talking with you. I want to thank everybody else, and we'll see you next